Hello, everyone. My name is Beverly Allen. I'm a Tacoma-based attorney. My practice is primarily in family law. And today I'm going to be talking to you about parenting plan modifications, as well as a few points about how that impacts child support. Before I get started, my views that I am sharing are my own. They do not create a attorney-client relationship, and I'm not speaking for Pierce County or the Pierce County Law Library. So with that said, let's get started. So a parenting plan modification. The first point you need to know is that you need to have a parenting plan to modify. So if you and the other parent are simply working off of an informal arrangement, there is nothing to modify. The danger of an informal arrangement is that either parent could elect to simply not honor the agreement, not turn over the child. In that instance, people often think, well, if I call law enforcement, they will help me out. Now, while law enforcement can certainly respond and keep the peace, they will almost uniformly instruct you that this is a civil matter and you need to file in court. So, get a parenting plan. I have had two instances where there has been two children and only one of them was covered by a parenting plan. Now that happens if the parties have a parenting plan and then find themselves pregnant before they are able to finish that parenting plan and never add the second child onto the parenting plan. It can also happen if the parties are in an on-again, off-again relationship, and during the period that they are off, they have a parenting plan for the older child and then subsequently go on to have a second child. In those instances, a petition to modify can be filed for the older child, but for the younger child, you will need to file a petition to establish a parenting plan. And as long as the other parent is on the birth certificate, or you were married, or within, I believe it's 200 days of the divorce, you can go ahead and file a normal petition to establish parenting plan because you'll either have a presumption or parenting will be established by that birth certificate, which is, of course, based on the affidavit of paternity that needs to be filed to get the parent, the unmarried parent, on the birth certificate. All right, so you have a parenting plan in this scenario, and let's say you've established a parenting plan for the younger child, and now you need to go ahead and modify the parenting plan for the older child, or just modify for both children because you had a parenting plan for both children. In that scenario, you need to first determine whether there are any venue issues. Now, by that, I mean if your parenting plan was from another state or from another county than the one in which you find yourself living, you will need to establish the parenting plan in the county that you are living. In order to do that, you will need to file the parenting plan as a certified copy along with your petition to modify the parenting plan. If you do it that way, there is no need to go through the original venue. Now, you will still need to make sure that it's a correct county. Generally speaking, if the children have been living in the new county, and let's just use Pierce County as our example, then there is no need to establish the reasons for venue. The children have been living there, they are established there. Presumably the other parent has also had contact with this county because they're exercising their visitation. So if you have a parenting plan, simply obtain a certified copy of it if it's from a different county. If it's Pierce County and you're filing in Pierce County, you just need to file the petition under the cause number. There will be a filing fee for the petition. Those schedules, those fee schedules are on the county website. Okay, so once you've decided I have a parenting plan, I know where I'm filing, the next step is, do you want a major or a minor modification? Now, for a major modification, you are talking about having a serious issue or problem, one that affects the children's well-being. And the reason for that is that parent plan modifications are presumed to be against children's best interest. The courts favor continuity. In general, it's believed that if the children have a schedule, keeping that schedule is in their best interest, both psychologically, emotionally, and it's better for their development. So you need evidence to show why there is a problem that is serious enough to either change custody or change the time that the children will be spending with the other parent by more than 25 days, or if it's less than 25 days, more than 90 overnights. So that's the difference between a major modification and a minor modification, is the number of days that you are talking about changing. Or if you are talking about changing the custody designation, you need to have a good reason. You also need to have evidence, because that's the next piece of the analysis, is adequate cause. Whether it's for a major modification or a minor modification, the court is going to put a gatekeeping step in your way that you will need to overcome in order to proceed to a final decision on the merits of your case. And that gatekeeping process is called an adequate cause hearing. So you need to first file your petition to modify, and if it's from a different county, your certified copy. That's step 2. The third step is you need to file your proposed parenting plan, what you want the court to do. And the fourth step would be to file your motion for adequate cause. Now, it's easier to get a minor modification than to get a major modification, particularly if it's been several years since your parenting plan has been in effect. But you still have to have a reason, which means you have to have evidence. Child hearsay alone is not going to be, first of all, it's not going to be admissible. And second of all, even if the court hears your statements about the child, they'll need something more. So what is that something more? For evidence that the court can hear, usually it will be in the form of school records. There's a problem with the children's performance, and it's a problem because of the parenting plan. It could be counseling records, where the counselor notes there's a problem with the relationship between the other parent and the child. It could be medical records. It could be CPS reports or police reports. It could be other witness declarations of what they've seen the other parent do to the child, say to the child, how they've seen the other parent treat the child. So those are all possibilities. And again, it's easier to get the parenting plan changed if you're not changing the primary custodian designation and you're not changing more than 24 overnights with the child. So if it's less than that, then you'll have to do less convincing of the courts to change the parenting plan. You'll still need a reason, and you'll still need to be clear on what you want and propose your parenting plan. Now, before you get into court, I strongly suggest that you do alternative dispute resolution. In fact, your plan may require this before you can go ahead and file for your change. Look at your dispute resolution provision, and if it says you need to do an alternative dispute resolution, commence that process. If the other parent refuses to participate, get the proof of that. Ideally get a letter from the Center for Dialogue and Resolution or from another mediator that says, I tried to commence this process, the other parent didn't engage. If you have that letter, the court may excuse you from having to participate in alternative dispute resolution and may allow you simply to set your case for a hearing and for trial. So you have your evidence, you have your petition, you've engaged in dispute resolution, and you're before the court for adequate cause. So in that hearing, explain to the court why the change is needed, why it is in the children's best interest, and what evidence you have to support that. If you get through adequate cause, your case will then be set for trial. However, there will be a second opportunity to engage in alternative dispute resolution. To take advantage of that second opportunity, take advantage of all alternative dispute resolutions, because it is much more likely that the court will approve a plan that is agreed by the parents. And if you have an agreement that the change is needed, you will also not need adequate cause. You won't need that gatekeeping process because the other parent will have signed off on adequate cause. So there are a lot of moving parts in this whole process, and there are a lot of documents you need to file: the petition, the parenting plan, the motion for adequate cause, certified copy of the parenting plan if it's from a different county or state. I am more than happy to do a free consultation with anyone who needs some guidance on this process. I also have walk-in Wednesday clinic hours. You can reach me at 253-778-6376 or on my Facebook page, TacomaLegalCoach.com. If you have any questions, please submit those to the page or give me a call. I'm more than happy to walk you through this. Thank you for tuning in, and please check out the Pierce County Law Library for any further resources. Thank you.